Welcome back. I trust everyone had a good lunch. We'll do calisthenics for the next 5 minutes to wake everybody up for the next presentation. I don't think we'll need to do that, actually. We should be pretty well riveted to this. And I hope all of these presentations are being very beneficial to you and your education. Our next speaker is a real hero in the state of Michigan. Paul Reingold is a professor emeritus at the University of Michigan, where he directed the Civil Criminal Litigation Clinic from 1983 to 2018. Before joining the law school faculty, he served as a legal services attorney, specializing in cases against state and federal governments. His primary interests include civil rights litigation, appellate practice, prisoners' rights, and civil procedure. Mr. Reingold has taught trial advocacy, litigation ethics, negotiation, and clinical law, and is a past recipient of the L. Hart Wright Award for Excellence in Teaching. He also has taught as a visiting professor of law in Japan and Spain, and is a visiting clinical professor at Boston College Law School. He has served on the board of directors of the clinical law section of the American Association of Law Schools and was a founding member of the editorial board of the Clinical Law Review. Closer to home for us, Paul was one of the principal architects behind the Doe's v. Snyder cases, in which the Michigan sex offender registry law was found to be unconstitutional, and a federal appeals court went on the attack towards some of the elements of these laws that have become common across the country. The two Doe's v. Snyder cases will be the primary focus of Paul's presentation today. It will largely be a dialogue, so we invite you again to raise your questions by clicking on the Ask a Question link at the bottom of your screen. And if, in case you weren't here this morning to hear the explanation, you'll see a pop-up window when you click on Ask a Question, and you'll see previously posted questions there. So if yours happens to be there already, you can simply upvote the one that's there by clicking beside it, or you can type in a new question if you like. So please do participate this afternoon. Paul is looking forward to your questions and a dialogue during the session today. So we welcome Professor Reingold. After a quick transition here, you will be on the air.
Great. First, thanks for inviting me. This is the, I think, third NARSOL event that I've been able to participate in, and I'm happy to be returning. I've been asked to talk about Michigan. We've got what at this point might be the longest running challenge to SORA that's still going on in the courts. I know that some of you know the history, but I'll summarize it as I have in the past to bring everyone up to speed. You all know that the federal SORNA was passed back in 2006, and one of its goals, maybe its primary goal, was to create national uniformity as to sex offender laws. The inducement to the states to get them to buy in took the form of a quid pro quo, and that was that states that failed to opt in would lose their federal burn grant money, which is a congressional grant that helps fund law enforcement and prosecutors' offices. Well, 14 years later, after 2006, we can say with certainty that the federal inducement didn't work. The states who looked at what SORNA, the federal law compliance, would mean, quickly realized they were going to be buying a pig in a poke. The cost of SORA compliance would dwarf the lost burn grant funds. Adopting SORNA would probably create a permanent pariah class because of the lifetime registration. And even back in 2006 and 2010, there was very little evidence that super registration laws like SORNA produced any demonstrable public benefit. The predictable result was that SORNA compliant states would wind up, like Michigan, with a bloated registry that was hugely expensive to operate and with little or nothing to show for it. 14 years after SORNA was passed, only, I think it's now 18 states have opted into the federal regime and adopted SORNA compliant laws. Michigan was one of those states. It amended its SORA in 2011, incorporating all of the requirements for federal SORA, which you're familiar with: a conviction-based registry, reporting of vast amounts of information, 3 tiers, 15, 25 years, and lifetime registration, a recapture provision, which imposes retroactive registration for anyone who's convicted of a new offense, sex-related or not, and of course, strict monitoring and enforcement of reporting violations. Michigan also kept or added some draconian provisions of its own. It had a 2006 amendment that barred living, working, or loitering within 1,000 feet of a school, and it had an even older immediate in-person or in-person reporting from any categories of information. And in 2011, that became immediate in-person reporting. It's interesting how these cases get off the ground. You know, I did not have a history of working on sex offender law. As you heard in the introduction, I've mostly been a teacher and clinical law litigator on local cases, and my specialty had been civil rights cases in federal court on behalf of prisoners, mostly lifers. So I came to learn about SORA only because a young lawyer, Miriam Ackerman, in Western Michigan was doing reentry work with prisoners. And she noticed that nearly all sex offenders were getting parole conditions that made it impossible for them to return home to their families if they had minor children. The bottom line was the Michigan Department of Corrections presumed that anyone who'd committed a sex offense was a danger to his or her own children. And so the parole board's computer automatically assigned a condition of no contact with minors, which included the parolee's own children. To Miriam, this was nuts. She was a reentry expert, and she knew that successful reentry depends on a stable, supportive environment, which for most people means coming home. I didn't know much about reentry, but I'd litigated a lot of prisoners' rights cases. And so when Miriam called me, we both thought we would make a good team. We ultimately filed and settled the case, challenging the parole board's policy. The state agreed to switch the computer default 180 degrees, a result that made it far easier for people leaving prison to connect with their families and quickly reestablish bonds with their children. Miriam and I were pleased with that success. And so after Michigan passed the SORNA-compliant SORA amendments in 2011, we set our sights on a challenge to the new Michigan law. As experienced lawyers, we knew this was going to be an uphill battle for at least 3 reasons. First, many SORA challenges had failed, especially in federal court. So the case law was mostly against us. Part of the reason for this was that many of the challenges involved only narrow parts of the law, you know, criminal provisions that people had been convicted or under which they were being charged, like SORA reporting violations. And so they tended to be narrow challenges. Second, many of the challenges arose in the context of a criminal appeal where there's almost no factual discovery and therefore little or no factual record. And third, back in 2011-12, the core justification for SORA laws was that sex offenders had, as you know, frightening and high recidivism rates, which meant both legislatures and judges were working off the assumption that everybody posed a danger to the public for a very long time, if not forever. And of course, the greater the perceived danger, the more the courts were going to defer to the legislature in these kinds of statutes. So we knew we needed a new and a different tack. We decided to try to file a global challenge to Michigan's law, putting the emphasis more on the facts than on the law. Our goal was to develop a broad and deep factual record based on modern social science research. We also wanted to show the harm caused by these new super registration laws. And we wanted to make the case that such laws do little or nothing to make the public safer. We thought if we could establish those 3 things, we had a chance. Because this was also going to be a civil case, we had the luxury of being able to recruit the best possible plaintiffs, unlike in a criminal case where you just take the defendant that you've got. And we were able to find people whose situations could help shine a light on the insanity of these laws. Our plaintiffs were all lifetime registrants, and I'll give you a quick idea of the kind of people we recruited. One was a man who never committed a sex offense. He'd been involved in a robbery. In the robbery, he moved from people from one room to another. One of the people had a teenage child with him. The child was also moved. That became child kidnapping, a lifetime registrable offense. Another was a man who'd met a woman at an 18 and over club. She had a forged ID card. He didn't know that she was over 18 for a long while. They later married and had 2 children together, and they remain a couple today. He's on the registry, was on the registry for life. We had a woman who was taken off the Ohio registry where she had committed her offense because under Ohio law, she only had to be on the registry for 10 years. But when she returned to Michigan, she was nevertheless treated as a lifetime registrant, and but for Doe's 1 would remain on the registry. The last was an elderly man who became a lifetime registrant under the recapture provision. He was arrested for taking some scrap metal out of a house, an abandoned home in Detroit. This was like 30 plus years after his sex offense, and he became obviously a tier 3 registrant. So Doe's 1 with those plaintiffs took 4 years to litigate, thousands of hours of attorney time. The record included some 24 lengthy depositions, about 3,000 pages of documents, a 300-page joint statement of facts, and 7 expert reports. Ultimately, the district court in 2015 held parts of SORA to be unconstitutional, mostly under the Due Process Clause and the First Amendment. The court said that parts of the statute were so confusing that neither police nor registrants could figure out what the law required, that the school exclusion zones were too vague to be enforceable. No one knew where they started or where they ended. That some reporting of online identifiers, internet identifiers, violated free speech, the First Amendment, and that in-person reporting within 3 days was unjustified and put too big a burden on registrants. And finally, that the law was so hard to understand that going forward, only willful violations of the law could be prosecuted. You couldn't be prosecuted for a per se violation. This was very good news, but the district court denied our primary legal claim, which was that SORA violated the ex post facto clause as applied retroactively to people before the 2011 amendments. Both sides appealed, and the Sixth Circuit reversed the district court's dismissal of the ex post facto claim. The appeals court held that taken as a whole, Michigan SORA was so onerous that it rose to the level of punishment and therefore could not be applied retroactively under the federal ex post facto clause. That was great news, but it also meant that because all the named plaintiffs had committed their registrable offenses before 2011, SORA in its current form no longer applied to them. It would be blocked, which meant the Court of Appeals did not address the other issues that both sides had appealed. In other words, because as to the 6 plaintiffs, the law couldn't be applied against them, it no longer mattered whether it was vague or if it violated the First Amendment, because they weren't going to be affected by any such rules. The state appealed that ruling of the Sixth Circuit to the US Supreme Court, and in the fall of 2017, early in 2017, the US Supreme Court, let's see, when was it? Late in 2017, the US Supreme Court chose not to take the case. That made the Sixth Circuit opinion final and binding on Michigan officials. And on remand in the fall of 2017, a final judgment was entered holding that SORA is unconstitutional and enjoining its enforcement as to the named plaintiffs. Now, you'd think that winning a lawsuit like that would mean getting the relief that you want. especially though if you haven't filed the case as a class action, that's not always true. In Doe's 1, we had planned to file the case as a class action. In the end, we chose not to because we drew a very conservative district court judge who we thought was unlikely to rule in our favor, and we didn't want to poison the well for registrants all across the state. Turned out the judge was very even-handed, very sharp judge, and we won significant claims before him, even though we didn't win the most important one. We also knew that once a law is held to be unconstitutional for a few plaintiffs, the state nearly always cures the defects in the law quickly for everybody. They do so, the states do so to avoid a flood of copycat lawsuits that the state is almost surely to lose. Indeed, after Doe's 1 was remanded and the judgment was entered, opposing counsel and other state officials reassured us that a legislative fix would be just around the corner. But we all expected the legislature to act, in part because it now had a perfect excuse to do so at no political cost. The legislature could say, the courts made us do it, right? The perfect out for a legislature. But nothing happened. Over the next few months, the legislative silence was deafening. At some point, we realized that the corner was not going to be turned. And so in mid-2018, we filed a new class action complaint in the lawsuit that has come to be known as Doe's 2. We teamed up with a private lawyer, a woman named Allison Oliver, who had handled class action cases. And she had filed a class action a few weeks after the Doe's 1 Sixth Circuit decision, hoping that hers would then be first in line, the first filed case, if new litigation was required in order to expand the reach of Doe's 1. That case had been held in abeyance pending the appeal to the Supreme Court, but it got reactivated when we joined forces with her and came back into the district court with a class action. As in Doe's 1, we wanted to get the best possible plaintiffs, but it was a little harder this time because with a class action, the plaintiffs must be representative of the class. And we were going to have 3 classes: those whose registrable offenses predated 2006, when the school exclusion zones were added, those whose registrable offenses were between 2006 and 2011, when the SORNA compliant amendments were added, and then those whose registrable offenses occurred after 2011, that is, people who would not have an ex post facto claim because the new amendments would only apply to them prospectively. So they would only have valid constitutional claims of the sort that the district court had found in their favor on, as opposed to the ex post facto claim. Again, we were able to find sympathetic plaintiffs to represent all 3 of the classes and subclasses. I should say, because all of the legal claims in Doe's 2 were going to be identical to what we had already won in Doe's 1, the court also allowed us to incorporate the full factual record from Doe's 1 into Doe's 2. To be clear, the point of Doe's 2 was not to bring new or different legal challenges. It was simply to expand or extend the district court's decisions and the Court of Appeals holdings in Doe's 1 to all qualified Michigan residents. So the goal was to take a victory for 6 people and make it a victory for 44,000 people. In mid-2018, we moved for class certification and partial summary judgment on all of those claims. This is actually a good place to pause just for a second to comment on the dilemma that the lawyers and the plaintiffs face in bringing these cases. Our goal in bringing Doe's 2 was not simply to extend Doe's 1 to all 44,000 registrants. Because if we did that, the relief we got was going to be limited to what the courts had held in Doe's 1. So our goal was more ambitious than that, and it was to get the very best possible new law that we could get going forward. Courts can't rewrite new laws. all they can do is tell the legislature or other state defendants that a law is unconstitutional and enjoin the law if the state doesn't fix the defects. So any court ban was going to be narrower than what we hope to be able to get if we could work with the legislature in crafting a new law. Our view was that if we could educate the legislative and executive branches and get them to adopt a law that was based on modern social science research and smart law enforcement policy and efficient use of state resources, so that it might actually improve public safety at a fair price without punishing 44,000 people, then we might get a better law than the limited changes that the courts might require under DOE's 1. So from the start, our goal was to get the best possible new statute that we could. Another problem and another reason why we were willing to let the DOE's 2 case proceed slowly was that 2018 was an election year. And the last thing you want to do is Sex Offense Registration Act reform a few months before a November election. Legislators view this kind of reform as toxic, and they are not going to want to do what you're hoping to move them to do. We also were hoping that the 2018 election in Michigan would result in a better incoming administration in January of 2019. And that turned out to be true. The Democrats retook the Michigan House. The new Attorney General was Democratic. And at least for a while, it looked like we were going to be able to make more headway. With the new administration's blessing, we began meeting with a work group in the state capitol. And this was a great work group. It included representatives from the state police, from the Department of Corrections, from the Prosecutors Association, both houses of the legislature, from the governor's office, victims' rights advocates, the ACLU. It was some 25 people in all. And we met for a while weekly. To keep the pressure on the work group and the legislature, we also moved forward in the district court. In the spring of 2019, the court entered a declaratory judgment on the bulk of our claims, in effect adopting the holding of DOE's 1 as applied to the class and subclasses, but deferring any decision on injunctive relief to give the work group and the legislature more time to act. In my opinion, by August 2019, the work group was within shouting distance of a truly improved new law, one that would cut costs, improve public safety, get rid of the worst parts of the old law, like the school zone exclusions, reduce the length of time on the registry, and create a path off the registry for thousands of people who weren't dangerous to anybody. We weren't there yet, but there was beginning to be consensus in the room that SORNA-type legislation is what I said at the beginning, a pig in a poke. It's expensive and it doesn't do anything. Unfortunately, all that progress stalled when in late August or early September of 2019, the executive branch more or less pulled the plug on the negotiations. Now, we don't know why that happened. Some of us suspect that maybe the governor had hopes of being a national candidate or a cabinet appointee in a new Democratic administration after the 2020 election, or may have simply felt that reform of the state sex offender law early in her administration would be, again, toxic to her politically. But the result was the negotiations stalled. And so in the fall of 2019, we had no choice but to go back to court seeking a decision on all of the pending leftover motions. In February 2020, the district court granted all of our motions, all the declaratory and injunctive relief that we had requested, but it once more gave the state a, quote, last chance to enact a new law. That was a 60-day reprieve before the injunctions shutting down SORA retroactively and limiting it prospectively would take effect. So that brings us almost up to date, but not quite. We expected the judgment to enter in March, but we all know now what happened in March. The COVID pandemic hit, making it impossible for state government to do any of the things that would have been required under the judgment that the court would have entered. The legislature wasn't meeting, it couldn't act. The state police couldn't do the work to figure out who fell into which of the classes and subclasses. The state police couldn't notify registrants of their duties if SORA lapsed or changed. And within weeks, registrants couldn't register because of state and federal stay-at-home orders and then the closure of police stations. So there weren't even places to go register. In Doe's 2, the parties sensibly agreed to delay entry of the final judgment until the emergency was over and the judgment could be implemented by the defendants. And to protect registrants, in March 2020, the court entered a broad order suspending enforcement of most of SORA's key requirements, in effect creating a kind of temporary immunity until, one, the emergency ended, and two, all registrants were notified notified individually that their duties under SORA had been or would be reinstated. That order remains in effect today. All right, as a wrap up, I'll tell you that as the state government began to figure out how to conduct business during COVID in the summer, the House Judiciary Committee took up a draft new SORA bill. Unfortunately, it was a truly horrible bill. It was basically the current SORA bill with as few possible changes made to it as they thought they could get away with. It retained most of the features that the Sixth Circuit had said constituted punishment. There were some Zoom hearings in July and early August. 30 or 40 people testified. I think only one person was in favor of the bill. Luckily, the HJC, the House Judiciary Committee, tabled the bill without action. In September, when the legislature still had not acted, but the wheels of state were now turning again, we filed a motion for entry of a final judgment. That motion has been fully briefed by both sides, and we're awaiting the district court's decision. Finally, the very last thing is, our understanding was that the House Judiciary Committee was going to bring back this awful bill and try to pass it during the lame duck session between now and Christmas. We continue to hope that that does not occur. The ACLU is actively lobbying against it, but it's not impossible. If it passes, we will have no choice but to go back to court, either to try to enjoin it in the Doe's 2 case, or by filing a new Doe's 3 case after the start of the year. Our view at this point is that if what Michigan is going to do is pass a SORNA compliant law that has almost all of the same defects as what the current law has, we will have no choice but to sue them again. So we're awaiting a final decision from the court, and we're also waiting to see if the legislature will act. That's a summary of Doe's 1 and 2. And I know that our moderator has some questions for me, and we will also be taking questions from our participants.
Thank you, Paul. I do have a few questions that have been submitted. Could the legislature, and I think you kind of answered that, could the legislature pass a bill that is outside what the court has ordered and end up not doing what the court ordered?
The answer is yes, and that might well happen. At the moment, there are really 3 things that the Michigan legislature could do. One is it could do nothing, and if it does nothing, the court will at some point enter the judgment and might give the legislature a little more time after the judgment to do something. It might not. It might say enough is enough. If that occurs, as to the people who have the ex post facto claim, that is everyone pre-2011, SORA will disappear. They will no longer be covered by the current version of SORA. And people going forward, post 2011 registrants, will have the benefit of the district court decisions that held parts of the statute, like the school exclusion zones and the immediate reporting and having to report phones and cars that are used regularly. No one understood what that meant. All of those provisions will drop out, but their obligations will continue. The second thing the court can do is pass a limited law. As I said, we will challenge it. The third thing, and in my view, the only intelligent course, is to do what they should have done years ago, and that is said SORNA is worthless, expensive, wasteful, and harmful, and come up with a law that is evidence-based, that's smart policy, and that will benefit the safety of communities, the fisc of the state, and registrants, the vast majority of whom don't need to be on registries of the sort that the super registration laws require.
Thank you. Paul, can your case be applied to other states?
It can be. As I said at the outset, the hardest part with this kind of litigation is it takes forever. You have good lawyers representing the state. The state's attorneys general cooperate in defending these cases. And so what it takes to win a case is not just able and experienced lawyers, but access to resources. You need people nationally with experience with whom you can consult and figure out a winning strategy. The cases that predictably make the worst law are ones where lawyers representing a single client raise more claims than are necessary in that case and don't know how to litigate the case and wind up making bad law or reinforcing bad law. So my view is anybody who enters a field like this, anybody who's doing any serious civil rights work, you need to be working cooperatively with skilled lawyers nationally so that you know what you're doing and you're making the best possible arguments and you're building the best possible record. There are some very good lawyers out there. The bar, the lawyers who are doing plaintiffs' sex offense appeals and challenges is very well organized, and I have nothing but admiration for the work that they're doing.
Thank you. What do you think the biggest takeaway from the Michigan Does 1 and 2 litigation is?
I think the biggest takeaway is, well, it's a lesson that I learned a long time ago, and that is that when you're a lawyer, you think that doing litigation is going to solve the world's problems, and more often than not, even when you win, if you're representing politically unpopular people, it's very hard to retain the win or to maximize the win. And what it means is if we're going to really change the world on this issue, it's got to be done on all fronts. It can't just be litigated cases. It's got to be education. It's got to be really coordinated, skilled lobbying. It's got to be press. I've always thought the legislators were wrong when they're afraid of these cases. They were afraid of fixing a broken registry. In our state and around the country, you see a combination of liberal and conservative press in favor of fixing this. It's not rocket science, right? We know that when you have 44,000 people on a registry, and we know that when the vast majority of them are never going to commit a second sex offense, why are we doing what we're doing? It is crazy. I may have said this to this group before, but my view is whenever you see a law that's named after somebody, look out. When you have a child's name on a criminal law, it means it's being passed in part vindictively, right? It's not a thought through law that says, what's the real problem and how do we solve it? And so the deep law here is you need the social work research, the social science researchers. You need the press. And it's got to be a coordinated long-term process. When I look around at the cases that are being decided, the lawyers group, the sex offenders lawyers group that I belong to, has a newsletter that comes out weekly and monthly. And every month when I review the new cases that have come out, some months I feel like, 2 steps forward, great, 1 step back. Other months it's 1 step forward, 2 steps back. But there's progress. There's a lot of courts that are saying these laws don't do what they're supposed to do, and the harm they inflict is massive. And they're more inclined, the courts are more inclined to throw out parts of the law. On the other hand, what I said at the start is true. The federal law on SORNA is bad. Most circuits have upheld it. Now, I think we need to have an attack on SORNA, but you want the best possible case to go to the US Supreme Court. You want one with a record like Doe's 1 and Doe's 2. And it's hard to build that. It takes, years to build it. But I think the older cases, the older federal cases, I think are now out of date because no one could foresee what the internet would become and how being on a registry would become the first thing that the world would know about a person, even if the person is not dangerous to anybody, and even if their offense is 40 years old. And I think that's a radical change. I also think it's not just the internet, but the social science has changed. We now know, we always knew, we just allowed our views to be distorted, that these laws are based on myth and fear. And the social science is clear and has been clear for decades. And that is that sex offenders have the lowest recidivism rates of any group of felons except for murderers. And it's not just a little lower, it is substantially lower. And yet, this is the group that gets targeted with these super registration laws. It is truly nuts, but it's got to be an across-the-board change.
Thank you. You kind of led into the next couple questions that we've received. And this one will kind of drill down maybe more on it for some people. What do you see as the next important SORNA litigation nationally?
I think what lawyers are doing now is the right approach, and that is, we've got a new, very conservative Supreme Court, and in my view, that probably means we want to stay away from it. To the extent that state courts are open to these issues, I think that's maybe the place to be litigating. It turns out the Michigan Supreme Court took a SORA case almost 2 years ago. It held argument on the case and then chose not to decide it. It thought that the Doe's 2 case would be decided in the interim, and it has not been decided. It was argued again in October of 2020, and the parties are awaiting a decision. It's possible that the Michigan Supreme Court will duck the broad SORA issues and simply, issue a very narrow decision. It's possible they'll take on all the issues and agree with the Sixth Circuit. It's possible they'll disagree with the Sixth Circuit. But I think you want to be looking for favorable forums. When I said there were 2 steps forward and 1 back, or 1 step forward and 2 back, we had a great opinion in Denver a couple of years ago from Judge Mach, a Michigan grad, I should point out, Michigan Law School grad, where he really looked carefully at the effect these statutes have and held it to be unconstitutional, held the Colorado statute to be unconstitutional. It got to the 10th Circuit, and it was a panel that had no interest in delving into the record and simply said, oh, other circuits have said no, and we've kind of said no, and the answer is no, and it's reversed. And I think ripe for change, but those cases are going to keep coming down too.
Okay, a couple more, few more questions actually. I've got quite a few more. If a person was convicted out of Michigan and they moved to Michigan, will the new laws apply to them?
The answer is yes. If you are someone who committed a registrable offense outside of Michigan and then you move to Michigan, we are a state that looks at the crime as defined in the state where you committed it. And then we look at the closest comparable Michigan offense. And under current law, your status, your tier status is determined by what that most comparable offense in Michigan would be. So if Michigan passes a new law that's still very close to SORNA, I don't see that that would change. And I assume that if you move into Michigan, you're going to be whatever you would be under Michigan law. If Michigan passes the kind of law that some states have, where your duty to register here is tied to your duty to register in your the state of the offense, then things could change, right? Some states do that. Their view is, well, if the home state doesn't think the person should be registered, why should we? And they simply defer. I know that the legislature, one of their concerns has been, well, if we make Michigan much less restrictive than the states around us, we'll get a flood of registrants coming into the state to take advantage of our lenient law. Well, I don't know of any studies anywhere that suggest that sex offenders move en masse because of changes in state law. There may be, I know of a few people who had job offers, say, in 2 different states and out of state, and wound up accepting the one in the state that had a more favorable registration law. I won't say it doesn't happen, but the idea that that should be a legislative concern is if there's going to be, tides of people. I just don't think the world works that way. And I would be surprised. I mean, there are already wide variants all across the country, and you just don't hear about people moving in any kind of numbers for that reason.
Thank you. Next question has to do with international Megan's Law. Does removal from the state's registry trigger removal from the U.S. passport sex offender statement on the passport?
I believe the answer to that is no. I don't know that for sure, but even in Michigan, under SORNA, the federal law, even if the registrable offense is expunged, and I believe it might even be if there's executive clemency in your pardon for the offense, I believe that doesn't take you off the registry. There's also Sixth Circuit law, recent Sixth Circuit law, that makes it clear that there's a federal duty to register, even if you don't have a state law that requires you to register. Now, this is true all around the country, and no one really quite knows what it means because no one understands how it gets implemented. If you have a federal duty to register, but your state doesn't include you as a registrable person, where do you go, right? How do you register? It's simply not possible to do. And so if you're then charged by the feds for failing to register under the federal law, I think you'd have a complete defense that you couldn't register because the state wouldn't allow you if you're not registrable. What we're recommending that people do is if they're taken off the registry and for whatever reason, but are still governed by federal law, there's nothing wrong with simply saying to Michigan, I just want you to know I'm registering for purposes of the federal law. I don't want to be on a public registry, nothing else. I'm just telling you I'm officially registering, period. And at least then you've done it. But there are no requirements under federal law, and there's no enforcement under federal law that I'm aware of as to when you're supposed to register or how often, that sort of thing.
Thank you. Another question along the lines, since we haven't in Michigan had to register since March, are you aware of any rampant ramifications from that? In other words, an increase in sex offenses or anything like along those lines?
I am not, and I have to say, I think that's one of the outcomes we were hoping to see when we got the interim order, the emergency order that suspended enforcement. What it means is the 35 or whatever it is, 1,000 people who are not in prison and who are on the registry, it's not as if they're taking advantage of the of this downtime and running out and committing new offenses. I mean, we knew that wouldn't happen. Again, it makes no sense. If anything, during COVID, people are hunkering down. They're with their families more. They're trying to make a living if they've lost, trying to put food on the table if they've lost their jobs. On the other hand, Tim, this is not an issue to be sneezed at. Crime across the country went down initially in the first days of COVID and has risen markedly in the last few months. I was on a Zoom meeting yesterday with a new prosecutor in my home county, and he's one of these prosecutors like the prosecutor in Philadelphia and in San Francisco, who got in on a we want change kind of ticket. He's going to make major changes in prosecutions. And he said part of what's worried him is that the crime rate is going up nationally. And he attributes it to the rancor in the country, to the sense of fear and loathing among or between the parties, the political parties, the COVID weariness, and boredom. And there's more gunfire all across the country. And we all know from Willie Horton and in Michigan from a case in the 90s, all it takes is one horrible crime and all the ground that you've gained is lost. And so the answer is no, I'm not aware of any change. I think it should be consoling to legislators to know that we're all going about our lives as we did before. There is no change, but it doesn't mean there couldn't be a bad case that makes life tougher for everybody and gets blamed on this interim order.
Paul, we had another question that you kind of clarified, but I think this person wants a little more clarification. Their offense was in Michigan. They've moved out of state, and if they get removed in Michigan, should they be removed in their state that they moved to?
That's a great question, and we've been talking about that in the lawsuit because the state had some disagreement with us about that and about people coming in, whether they should be counted in the class or not, people coming in. But as to the people leaving, we've had that question from out-of-staters now while the law is being suspended. And they said, does that mean that I no longer have to register, in Texas or wherever? And if the law is struck down, does that mean I don't have to register in Texas? And again, as I alluded to a little earlier, that depends on how the state that you're in determines who registers, who has to register, and who doesn't. What we ask the state to do is to help us notify, once a judgment is entered, help us notify all out-of-state registrants, because in some states that don't require registration there, if the home state, the state where the crime was committed, don't require it, there might be a benefit. You might come off your new home state's registry. On the other hand, if you're in a state like Michigan that looks at Michigan's law, criminal law, and then looks at the home state's registration law, it won't matter whether you have to register in Michigan or not. You'll still have to register in that state. And as to the interim order, that doesn't affect registrants who are out of state. It's only the people in state who can't get to the registration places and where the legislature can't act that the order applies to. And so I don't believe there's any benefit in the interim period if you're out of state.
Okay. What do you think the prospects going forward, both nationally and at the state level, with SORNA issues?
Well, I'm worried about Michigan. We're just coming off a 2 or 3 or 4 year period where there's been a lot of really excellent criminal justice reform, and a lot of it's been bipartisan. We have several terrific advocacy groups in this state, and they've figured out how to get Democrats and Republicans on the same page. And we've had just a series of legislative changes that make expungement easier, that make it easier for lifers to get out on parole, that make youth justice issues easier. It's just issue after issue. We got a new law that makes it people who are wrongfully convicted can get compensation in Michigan, something we've been trying to get for decades. And all of these bills and more have passed. But the people I talked to are worried about the incoming class in 2021 of legislators. Michigan has term limits on legislators. There's a lot of people who come in at the start of every year, and they're worried that the leadership in the Senate and the House, both of which are Republican, will be more averse to criminal justice reform. And I'm afraid that's right. And since we already have a Democratic governor who's not willing to take a lead on these issues, or at least on the sex offender issues, I think 2021 and 2022 might be not the best time for there to be hope of change on this kind of work.
Thank you, Paul. I know we're getting near the end of our time. We've got quite a few more questions, but I'll try to narrow them down as best I can. Somebody asked the question about if they're removed from the public registry, there's all these private registries around. Is there any hope of them getting removed from a private registry?
That's another great question. It's outside the scope of the litigation that we've done because our defendants are only state agents, and the private registries obviously are not. What I was pushing for in the Michigan work group was to make sure that we included a provision that said if anyone was no longer on the registry and they remained on a private registry, that there would be either criminal penalties against the private registry or a civil cause of action for damages against the private registry, or both. And I agree, as long as we have private registries that are mirroring the public registry, it doesn't do a lot of good if they remain in effect while the public registry goes dark or people come off of it. And so I think that's a correction that the legislature is obligated to make as part of a new statute if more people are going to come off the registry.
And another question that's come in, it has to do with juveniles. The person believes that in the registry changes, or the changes that are being set forth at this time, that it doesn't remove enough juveniles, or in other words, they're saying it's over-inclusive for juveniles. Your thoughts?
I haven't read the most recent draft, but the draft that I read and that the ACLU commented upon, I believe that's correct. That some of the changes, some of the favorable changes for registrants, for young registrants that have been made earlier may not be included in this draft. And we don't know if that's just an oversight or what. I don't think there's any movement afoot to do this willfully. But as I intimated earlier, but once the negotiations broke down in DOS 2, and once it became clear that looked like the legislature was either going to do nothing or was going to act on the horrible bill that was introduced, we have effectively stopped negotiating. I don't want to be in the position of, improving it in small ways when the whole statute is horrendous. And what we want is for them to pass a horrendous statute, if that's what it's going to be, and we'll litigate it. We're not going to nitpick about small pieces of it.
Okay, thank you. The next question, I'm going to try to break it down a little bit more. Where did it go here? Boy. Okay, this will be my last question. If I can find
it. Better
it.
be a good one then, right?
Yeah. Well, I guess in general, what are your general thoughts? How do you think this is all going to end?
Well, I mean, if you believe what Martin Luther King said, and you think that in the end, the arc of justice, bends in our favor. I'm not quoting it directly, but if you think over time things get better, then the optimistic part of me says at some point the states will recognize they've got to do something. This is crazy to have more and more people on the registry for life, year after year after year. In 10 years, we'll be at the point where huge numbers of senior citizens who can barely get out of bed are still going to be on a lifetime registry. It's crazy. If anyone would actually look at the finances, they would know that we're spending 7 figures, 8 figures, whatever it is. It's a ton of money, so that we don't lose, like $900,000 in a burn rent. And so that doesn't make any sense. But one of the things that gave me, that made me feel good in the work group was that over time, the Prosecutors Association, the Department of Corrections, and the state police sort of got what we were saying. The state police especially were fairly candid. I remember them saying, we're not the ones who asked for this law. No one consulted us. And we can tell you, if we don't have school zones, you won't hear the state police objecting. We know they don't do anything. This is, why are we doing this? It makes people unemployed. It makes people not be able to see their kids at school. It makes people not be able to find housing. What's the point? All of those result in more crime that we have to deal with. And so common sense is on our side. But if you look at world history, there's a lot of times where common sense didn't matter, and we're in one of those periods right now in a country that ought to know better. And so it's, while I'm cautiously optimistic, a realist as well. And we need to be realistic and clear-eyed, and we need to work hard. That's what I would say.
Thank you, Paul. And I know that people around the country, and especially those in Michigan, appreciate the time, effort, and all the work that you put into this. And I appreciate you spending the time with us today, and we'll turn it back over to the NARSOL.
All right, my pleasure, and thank you to everybody who made this happen.